I think today is the second session and the continuation of your yesterday's class. I hope everyone is following the professor lecture. Okay, anyhow, please, Ramamurthy Garu, please go ahead. Thank you.
Okay, sir. Good evening to all. Today we have to discuss the intellectual property rights enforcement, how the intellectual property rights are enforcing. So what is this intellectual property enforcement? The question of enforcement of IPR becomes very important. Why? Because it is the incidence of copying, counterfeiting, and piracy of the products. So because of this, we have to learn what is the enforcement mechanism of intellectual property rights. Based on the World Trade Organization, so many times again and again they are emphasized on this violation of intellectual property rights because it is very easy to counterfeit because of the territorial limitation. So the growth of world trade and development of global economies also, it leads to the easy counterfeiting regarding to the territorial limitations. So it is necessary to ensure enforcement of intellectual property rights through the fair and equitable legal procedures. So the abuse of intellectual property rights by owners of right holders of intellectual property is very important. It is the other side of the coin, which has not received attention in India or in any other developing countries till 2008. But in the TRIPS agreement through Article 40, it gives that IPR should not be abused is inserted before enforcement provisions, which are listed in Article 41 onwards. Especially the European and developed countries are very particular in curbing the abuse of IPRs, and they do not allow exercise of intellectual property rights unless competition is ensured, meaning that they do not allow intellectual properties to develop into monopolies at all. Yesterday we are all talking about the intellectual property rights must also used for the innovations, must also used for the advancement of the society also. So in that case, the European and developing countries may pay more concentration towards the not to develop monopolies. So what are the activities which infringe the intellectual property rights? That is a major two one, that is counterfeiting and piracy. So the IP infringement is a thriving multi-billion-dollar industry with a global reach. This IP theft is conducted by well-organized and sophisticated criminal organizations. It has become a form of organized crime with its own experts specializing in production in the industrial sectors concerned, its own financiers, logistic experts, importers, wholesalers, distributors, right up to the end of the consumer. So there are no universally accepted or uniform definition of counterfeiting and piracy. But the counterfeiting is a term generally used in relation to the infringement of the trademark. At the same time, piracy, the term is used in relation to the infringement of copyright or related rights. So what is counterfeiting? Counterfeiting, what impacts on the counterfeiting means the counterfeiting impacts an even wider spectrum of industry sectors. From the luxury goods, the traditional victim of counterfeiting, to watches, fashions, and sportswears, perfumes, cosmetics, toys, aircraft supporting items, and automobile components, foodstuff, and pharmaceuticals. Almost all value-added brands are copied and sold as original products. As regards the piracy, the most affected industry sector is computer software, and the second industry is music, and the final industry, The third industry is electronic toy industry, which produces popular products such as video games like that. So what are the socio-economic consequences of counterfeiting and piracy? Basically, the counterfeiting and piracy, it do not hurt only the economic and moral interest of the individual, but it also affects its consequences are it affects the society and the national economy. Individual holders of intellectual property rights suffers grievous damage to their economic and moral interests. So if anyone infringes or anyone counterfeited or pirated of someone's intellectual property right, then his economic and moral interest will be suffered. The second one is the licensed manufacturers of affected products suffered a direct loss in sales revenue. For example, a company purchased a product from a particular inventor by paying some amount, but that was someone else was used this what the company A was signed to produce some good, then the company A was directly involved in the loss in its sales. And the third one is the state also loses the tax revenue when legitimate sales fall. And fourth one, it is very important, it generates black money. The counterfeiting and piracy generates black money, exercise a very pernicious influence on the national economy. The large incidence of violations tend to destabilize economy. So it also discourages the creative activity in a society. If there is no regulation regarding infringement, then who want to invent or who want to apply his innovative mind? So that it is a discouraging activity in the society. And the counterfeit and pirated goods do not have to be overly worried about the quality. So the interests of the consumers are at risk and is a threat to the security and health of the consumers also. So what are the enforcement provisions of intellectual properties? So intellectual properties are essentially negative rights. So there is a concept of positive right and negative right. So positive right means if you basically the term offense itself gives two definitions. The term offense, according to Indian Penal Code or Bharatiya Nyaya Sanhita, it calls what is offense. Offense is an act to do or not to do. So act to do means you are doing something which was not supposed to do, then that is an offense. At the same time, the act which is not ought to be done, that means there is an act you need not to done, but you have done. So in that case also, that comes under the definition of the offense. So like that, rights are two types: positive rights and negative rights. Positive rights gives the exclusive right, that means you can do whatever, but negative rights, they prohibited you to do something. So these IPRs are essentially negative rights in the perspective of others. So at the same time, these are private rights. Intellectual property rights are private rights. Why? Because for a particular person approached to that intellectual property boards for the grant of this recognition of the intellectual property. In that case, that is a private right to that particular person. At the same time, intellectual property rights are also called negative rights because the others are prevented, or the third party is prevented to exploit the inventor without the proper authorization from the holder. So the problem has become acute because the advance of technology has made copying and counterfeiting of articles, even at massive scale, easy, cheap, and quick. At the same time, storage and communication of information is easy and can be done anywhere. So national boundaries have become inconsequential for global commerce. So these intellectual property rights enforcement. What do you mean by enforcement? So the enforcement of intellectual property right means that legal and administrative provisions and structures that exist would come to the aid of the holder of the intellectual property right in ensuring that his statutory rights are respected by others and he is able to enjoy unhindered the limited monopoly that comes with the grant of an intellectual property right in accordance with the law. So this is the definition of enforcement of intellectual property right. So the enforcement of intellectual property means there is some legal provisions and administrative provisions, and some administrative structure exists. Those existing provisions and structures gives a holder of the intellectual property rights by saying that it ensuring that his statutory right is respected. So no one is infringed. If anyone infringes, we will take action based on the legal administrative provisions. So these provisions at the same time they enjoy unhindered the limited monopoly, because the term limited monopoly is very important. If you create absolute monopoly with regarding to the holder of intellectual property rights, again it is abuse. So it gives limited monopoly that comes with the grant of intellectual property in accordance with the law. So who makes the first move in enforcement? So first move, who will be make in the enforcement? So basically the IPRs are private rights, as already I discussed. So the person holding the right who is adversely affected by the alleged infringement has to seek the remedy. So the person who has holding that right, if anyone is violating or infringing, then he is the first person to seek the remedy. So naturally, it is from him to collect evidence to confirm his suspicion and allegation that his rights have been infringed. So the infringement is two kinds. One is innocent infringement and other is deliberate infringement. So in the case of innocent infringement, the person who infringed is not aware of the act which infringes the other intellectual property right. But in the case of deliberate infringement, the infringer wants to infringe the other's intellectual property right for any other benefit, like commercial exploitation. So, in the case of innocent infringement, if the right holder can go and told that infringer that you are so and so doing, so it will be infringing my intellectual property right, then the problem can be solved amicably, because the person who infringed is not have aware of the existence of IPR of that particular person. So in the case of innocent infringement, the problem will be solved amicably. But in the case of deliberate infringement, the legal right holder may approach either to the legal proceeding or alternative dispute mechanism to redress the problem. Evidence to determine the facts in intellectual property litigation. So what evidence plays a vital role to determine the facts in intellectual property litigation? Two forms of evidence are particularly important to determine the facts. One is expert evidence and another one is consumer surveys or market surveys. So the expert evidence, basically in any country, if you see that in India, there is no particular judges who are dealing with this intellectual property rights who has special knowledge. So in general, the judges in India are general sense. So they will deal with all the matters. In that case, if he has not experience in that matter, so he does not give a rational judgment. So in that case, he take the evidence from experts. So this is called expert evidence. The expert evidence may become important in litigation involving patents, where the subject matter may be technically advanced and complex. The subject matter is technically advanced, but in these days, judges allows the online e-court system, but before there is no such type of technology adoption in the courts. Till now, there is a lack of technology adoption in the Indian judicial system. So, in such cases, judges may tend to place heavy reliance on the opinion of the experts in determining the specialized and technical issues of the case. But some countries have judges with specialized knowledge, both in patent law and technology fields. For example, Germany, where 90% of cases of patent infringement are settled without the need for any expert evidence. So this results in considerable saving of the time and money for the litigation. India also established the Intellectual Property Appellate Board through the Trademark Act 1999, which would be served by the members with specialized knowledge in intellectual property rights. But these are only boards. But in courts, there is no specialized judges who are specialized in intellectual property litigation. So next, the second evidence is consumer service. So this consumer service is nothing but the litigation of trademark and unfair competition. This consumer service could also help in determining whether a trademark could cause confusion or not. So if anyone infringes, then the court look into the consumer's side, whether this creates any infringement, whether this creates any confusion or not. If it creates confusion, then it will be the judge will be relied on the evidence of the consumer service. So this expert evidence is more reliable compared to the consumer service. Next, enforcement of IPR. So remedies available to infringement of IPR are both legal remedies and administrative remedies. Yesterday we have talked that legal remedies and administrative remedies slightly. So the intellectual property rights holders also issues an injunction orders, famously known as the pre-trial orders in the case of infringement. So what is pre-trial orders? Pre-trial order is nothing but before the court trial starts. So there is issuing of some orders, those called as pre-trial orders, such as search order and freezing injunction. Search order is nothing but ant and pillar order. Freezing order is nothing but Mareva injunction. Why these names called ant and pillar order? Let's say search order. Search order is also known as ant and pillar order. Why this search order is called as ant and pillar order? This name derives from the case ant and pillar KZ versus Manufacturing Process Limited 1976. What happened in this case is, in this case, in UK, the Court of Appeal approved a procedure first. If a plaintiff can apply in camera without notice to the defendant to a competent court for pre-trial relief for a search order. Second, the court may pass an order directing the defendant to permit his premises to be inspected by the plaintiff accompanied by his solicitor. Third, the plaintiff has the right to seize, copy, or take photographs of any material relevant to the alleged infringement. So this procedure was laid down in the case of Ant and Pillar case versus Manufacturing Process Limited. Basically this is nothing but, in generally, if you go in the any case, there are two parties. Number one is plaintiff. Number two is defendant. So the plaintiff is nothing but the aggrieved party, the person who is going to complain in the court is called as plaintiff. That means he was the victim, and the defendant means the person on whom you are imposing such a allegation. So that person is called defendant. That means the person who you are alleging that he was done like that infringement. In the case of intellectual property, he was infringer, so he is known as defendant. But in general court proceedings, what will happen is, before registering a case, the plaintiff, the person who the aggrieved party, send a notice to the defendant, you are doing so and so, then you have to appear like that. But in the case of this ant-and-pillar search order, such type of notice is not required. So a plaintiff can apply in camera. Number second, the court, without the court may order directing the dependents to permit his premises. The court gave order to the alleged person to show your premises, which was inspected by the aggrieved party plaintiff along with his solicitor. Solicitor is nothing but in UK it is called as advocate. And the third point is, the plaintiff has to right to seize, copy, take photographs of any material. So during the time of searching, if he found something like it is similar to his intellectual property, then he can seize that, or he can copy that, or he can take photographs of that material. But to obtain this search order, the plaintiff must show to the court that he has extremely strong prima facie case of infringement. Prima facie means first among. Means first itself you have to show that there is a strong, extremely strong infringement, case of strong infringement. And the second one is the actual or potential damage to him is very serious. So even though if someone is using your intellectual property, if there is nothing damage caused to you, there is no potential damage to you, then the court cannot issue search order. We have to show that there is a potential damage to his intellectual property right. And third one is to show the clear evidence that the defendant have in their possession incriminating goods or material. So you have to give evidence that the defendant has the incriminated goods in his possession. So at the time of requesting the search order, you have to satisfy these three conditions before the court. Then only the court will approve the procedure. Like the previously we talked that without notice, the plaintiff can apply search order, and after the applying, the court will direct the defendant to permit his premises. Third, the plaintiff can seize, take copy, photographs, like that. But this also creates some loopholes by everyone making false allegations against others. So to eliminate this type of false allegations and to eliminate the abuse of the search order, in 1996, the two important provisions were made. Those are, the order should be executed during the business hours on a weekday, and the service and execution of orders must be overseen by an independent supervising solicitor. So previously, in the case of search order, the solicitor is accompanied to the plaintiff. So there is no independent solicitor. But in 1996, to eliminate the abuse of the search order, they added a new provision, that is, the search order must be overseen by the independent supervising solicitor. So this is with regarding to search order. The another area with regarding to anti-pillar order concerns with self-incrimination. Self-incrimination, if you study the Constitution Article 20, it talks about this 20 clause 3 self-incrimination. That means to give evidence yourself in the court or before the police station. So the search order may require that the defendant not only to deliver up infringing goods or supporting documents, but also to give information, say, about his source of supply or destination of goods being dispatched by him. That means when the in the case of anti-pillar search order, if you if a person is having the possession of some infringed goods, in that case he has to give information with regarding to how the goods are with you, what the source, and to whom you are supplying. So you have to dispatch all these relevant information. Next one is freezing injection. It is also known as Mareva injection. Quite this is against to the anti-pillar order. While an anti-pillar order authorizes an intellectual property right holder to enter and search the premises of the person who is suspected to be infringing the rights of the owner, but the Mareva injunction prevents the defendant from disposing of assets over which the plaintiff may have claim. So one way in anti-pillar search order, you are saying that you allow the plaintiff along with a solicitor to search in your premises, and there is another injunction, Mareva injunction. It prevents the defendant from disposing the assets for which the plaintiff may have claim. So they may also need to come to a judgment. So it is not uncommon that court's orders also have feature of both anti-pillar or Mareva injunctions. So some courts also sometimes it say that in any case some police ask the court that I want search order. So during the search order only, while it proceeding, and the defendant party went to the court and asked the injunction order. For example, in the case of search order and freezing orders, yeah, in the case of arrest, if you see, court itself issues the arrest orders or some act saying that if you do something, then the police can take you. So this is a legal provision. But you can go to the court. The person, the wrongdoer, can go to the court and ask for the anticipatory bail. That is without entering into the jail. So he wants another, also common in courts also. However, meanwhile, a Mareva injunction may direct a seizure of specified valuables in which, as per the evidence, gains from infringement have been invested. The courts take care that the defendant is not deprived of living or denied opportunity of carrying on a legitimate trade. So what are the challenges in enforcement? So yesterday also we were discussing this, the evolution of technology and global nature, complexity of intellectual property rights. These are all affects the challenges in the enforcement. So what are the legal frameworks? Legal frameworks is nothing but national laws, international treaties, regional agreements. So this comes under the legal frameworks. So infringing acts of intellectual property rights. So what acts will comes under infringement? So definition, what is the infringement? So infringement, the definition itself saying that infringement is the context of IPR when someone uses or distributes or exploits a protected work without the owner's permission or without a lawful authorization, then it is called infringement. So the infringement is nothing but without the legal holder's permission, if someone uses or distributes or exploits a protected work, then it can becomes under infringement. So this violation can involve copyright, copying, reproducing, adopting, or distribution of copyrighted material, using a trademark without authorization, or producing a product that infringes on a patent. So this comes under the infringement. So the infringement involves the unauthorized use of another's intellectual property. It violates exclusive right granted to the owner of the intellectual property rights. And it will create economic harm to the rightful owner. So infringement acts, the first one is patent infringement. If the patent infringes, so who can be, on what act, on what law, the punishment will be, the patent will be protected in the case of infringement. According to Article 28 of the TRIPS Agreement, it lays down that the minimum exclusive rights that the grant of a patent shall confer on the owner of the patent. So the patents are two kinds. One is product patent and another one is process patent. So in the case of infringement, the exclusive rights where the subject matter of patent is product, then third parties are prevented from using that product without the owner's consent. If the subject matter of the patent is process, it prevents, Article 28 of the TRIPS Agreement prevents the third parties not to use the process without the owner's consent. So an act can be said to be infringe a patent only if it is shown to violate a claim made in the patent application. Yesterday I also said that when the patent was not registered, then you cannot ask for infringement, protection of infringement. So to determine the scope of the claims of the patent is most crucial in deciding the exclusive rights and whether the act is an infringing act. So in the Article 28 of the TRIPS Agreement also it consists of the Finch post approach and the Pitt and Marrow doctrine. So what is the Finch post approach? Basically, it was the traditional approach in UK. It seeks to determine the boundary of monopoly strictly with regard to the words used in the claim and also with reference to the chemical and mathematical symbols and drawings. For example, what this Finch post approach, if anyone is law student is there, then he will understand. If there is a two doctrines while interpreting the any statute, that one is literal interpretation, okay, and another one is Pitt and substance doctrine. In the case of literal interpretation, what the right in the act itself, you should study according to the lines, but you cannot go in between the lines. So that comes under this Finch post approach. Okay, this Finch post approach, if in the patent application a person writes as a monopoly right, so he give a brief description regarding his innovation, then based on that document only, he will get the protection. So according to the Lord Russell, he also said that what is not claimed is disclaimed. That is, if you are not wrote in the patent application, then those rights which should not be asked to protect. So this is the Finch post approach. So this Finch post approach strictly with regard to the words used in the claim. But what comes under the Pitt and Marrow doctrine? In the case of Pitt and Marrow doctrine, it is go beyond that. when at the time of making of the application, even though you are not mentioning some elements, but your intention is showing that, then it would treat that intention, not what you wrote. Okay, in that case, the pith and marrow doctrine, for example, if a observation or if an consists of some integers, some are essential components, some are non-essential components. So the essential components and non-essential components, if you are mentioned only the essential components, you are not mentioned the non-essential components. But in the case, the pith and marrow doctrine, it would include all. The essential integers are fundamental to the invention and are like a pith and marrow of it. He need not you have mentioned there. But if those are essential to this invention, that can be comes under the invention protection. So in that case, it is called as pith and marrow doctrine. Next one, types of infringing activity in patents. Just wait, some network issue. Screen is not sharing. There is a small network issue, so my presentation was not opening. So the types of infringing activity of patents. So a patent may be infringed by an act which is performed either during the manufacture or before it or after it. So a product patent is first infringed directly when a product containing all the essential features of the patent product is made. The process patent is first infringed directly when the process is carried out. So the infringement of patents can be taken into three categories: infringement during the manufacture, infringement after manufacture, infringement before manufacture. So this infringement, during manufacture, so the act of infringement involves making a patented product or using a patented process. Patented process. Next, the infringement after manufacture. This would include acts like disposing of or offering to dispose of, using, importing, keeping for disposal, or otherwise the patent product. So this comes under after the manufacture, the infringement happens. infringement before manufacture. Before manufacture, also the infringement happens. So, which is with regarding to the occurring between the publication and before the grant of the patent. So, as yesterday I told that you can apply before 12 months. So, after that 12 months, you can submit the entire publication with concerned patent office. Then they should grant that patentability. So during that period, also anyone can try to infringe the patent. Next, we come into the trademark infringement. So the trademark infringement, so it generally occurs when someone uses a trademark that is identical or confusingly similar to a registered trademark without the owner's permission. So this can include using the same logo, name, or slogan, or making chances to trademark that could deceive consumers. Trademark infringement. So these have some effects. These are some losses or causes for the infringement of the trademark. There is loss of revenue, reputation of damage, consumer confusion, and finally they can take legal action also. In the case of TRIPS agreement, trademark infringement, the TRIPS agreement Article 16 provides the rights conferred on the owner of a registered trademark. So, on what grounds the infringement of trademarks comes? So, the infringement of the relation to advantage. Next, when you come to the industrial design infringement, the TRIPS agreement Article 26 makes some protection, that is, the owner of a protected industrial design shall have the right to prevent the third parties not having the owner's consent from making selling or importing. Or it also, the members may provide limited exceptions to the protection of industrial design, provided that such exceptions do not unreasonably conflict with the normal exploitation of the protected industrial designs. This design right is protected against unauthorized copying or substantiability copying of the design for commercial purpose. Next, in the case of geographical indication infringement, the TRIPS agreement under Article 22 sets up some provisions with regarding to protection of geographical indications. In respect of geographical indications, members shall provide a legal means for interested parties to prevent, number one, the use of any means in the designation or presentation of a good that indicates or suggests that the good in question originates in a geographical area other than a true place of origin in a manner which misleads the public as to the geographical origin of the goods. And another one is any use which constituted an act of unfair competition within the meaning of Article 10, Clause B of the Paris Convention, 1967, And also Article 23 of the TRIPS agreement. This Article 22 talks about patentability or copyright. But in the case of Article 23 of the TRIPS agreement, it talks about protection for geographical indication for wines and spirits. So use of a geographical indication identifying wine or spirit is not originating in the place indicated by the GI is to prevent even where the true origin of the goods is indicated. Next, layout designs and integrated circuit infringement. So the Article 36 of the TRIPS agreement, it consists of the layout designs and integrated circuit infringements. So in that case, the member shall consider unlawful if it do some of the acts performed without the authorization of the rightful holder, that is importing, selling, or otherwise distributing for commercial purposes of a protected layout design. An integrated circuit in which a protected layout design is incorporated, or an article incorporating such an integrated circuit, only insofar as it continues to contain an unlawfully reproduced layout design. Along with the registration of a layout design, if valid, gives the owner the exclusive right to use the layout design and to obtain relief in respect of a infringement. Copyright infringement. So copyright infringement occurs when someone violates the exclusive rights granted to the copyright owner of the creative work. This includes unauthorized copying, distribution, performance, or creation of derivative works. These rights are protected by law and can be enforced through legal action. So the common examples of copyright infringement includes downloading music without permission, sharing copyrighted movies online, or creating unauthorized copies of books or software. This. So some of the copyright infringements are reproduction, distribution, public performance. So actions and remedies for infringement. What actions and remedies you take for the infringement? So yesterday I also take that say there are three channels of remedies: civil procedure, criminal procedure, administrative procedures are there to deal with this infringement of the intellectual property rights. So the procedure should not create a barrier to legitimate trade and provide for safeguards against their abuse. They should be fair and equitable and not unduly costly and complex. There should be no unreasonable time limits or undue delays. So the TRIPS agreement also lays down other requirements for enforcement process. That is, right to be here and give evidence, right to have a prompt, reasoned written decision, judicial review against the abuse of the enforcement. So these are all actions for the infringement of intellectual property rights given by the TRIPS agreement. What comes under the civil proceedings? So there are three issues you should consider in the case of civil proceedings. Number one, who could initiate proceedings? Number two, against whom the proceedings can be initiated. Number three, which court will have the jurisdiction to try the case. For the answer to the first one, who could initiate? That is the person whose right is violated, known as plaintiff. So the owner of intellectual property right is aggrieved party here. So the owner can file a case. So he can become the plaintiff. For the second question, to whom against the case will be filed? That means who is violated. It can be called as a defendant. So here, the liability is, however, to be judged in relation to the territorial jurisdiction. For example, if a person outside jurisdiction of the country's courts supplies a protected article to a party again outside the jurisdiction, he is not guilty of infringement. For example, in India, one for one particular copyright material is there, so the material is protected by the copyright. So in India, if anyone without the authorization of the true owner, if you make so many copies, then it comes under the infringement. For that, for example, if a person who is outside India, in that situation, if he makes the copies outside of India and sold it to the another person who is also outside India, then there is no guilty of infringement according to this territorial jurisdiction. But if he is working in a common design with a person who resides within the jurisdiction and commits the infringement act, the first person is, in this case, jointly shows the liability with the infringer. Now, on which court should try? In India, a suit for infringement of intellectual property can be filed in a court not lower than the district court having jurisdiction. So that means you have to file a infringement case in the district court. So you cannot file in municipal courts or revenue courts like taluka courts, but you have to file. So it is not prohibited to file in case of high courts and supreme courts, but that is the original jurisdiction lies with the district court. But the exception to this also there, that is High Court of Delhi, Calcutta, Madras, Bombay, Simla, and Jammu Kashmir, which have the original jurisdiction of this infringement of the patents. So the civil court, by apply the provisions, may award injunctions, damage, or account of profits. So what is this? We should discuss what the remedies. Now, what is criminal proceedings? So the penalties for infringement in a criminal case are tougher than the civil proceedings. So the criminal penalties involve the imprisonment also. But to prove a liability in the criminal action, it is more stringent than in the civil suit. In the case of civil suit, we have pre-trial injunctions are there. Like we are talking today in the first our initial, that is the ant and pillar search order or Mareva injunction of the freezing order. But in the case of criminal suits, there is no immediate or pre-trial or interlocutory remedies like injunction. Okay, so the remedial actions has to wait for the outcome of the criminal proceedings. So the legal framework and guidelines provides under the TRIPS agreement aim at making enforcement of intellectual property in criminal proceedings is more effective. Administrative procedure. Apart from court, so as we see that before, there is some civil proceedings and criminal proceedings, and in the department wise also there is an administrative procedure. Administrative agencies can also take effective steps in the violation of intellectual property rights. For example, customs officers, excise officers, the commissioners of customs and excise officers, they can make their while they're at the borders, and in the case of airports, they are heavily present custom and excise department. So they can identify, if they identify the infringement of intellectual property rights, they can seize the intellectual property right, seize that infringement articles. So for this, we have completed the IPR enforcement. Now, moving further, the IPR litigation and settlement of disputes. What is this IPR litigation and settlement of disputes? So, as we see, the counterfeiting and piracy activities, these are more. So, civil litigation and criminal litigations are used to deal with IPR disputes. Along with civil and criminal litigation, there are alternative dispute resolutions also there, which refers to methods of resolving intellectual property dispute without having to start court proceedings has been gaining importance. The most arbitration. So this whole WIPO has established the WIPO Arbitration and Mediation Center for resolving the intellectual property disputes. Yeah, we are seeing the counterfeiting and piracy, and what are the socio-economic consequences of counterfeiting and piracy. So, what is to combating counterfeiting? So, the International Trademark Association gave a special report on counterfeiting in 2004. It engaged again. There was a network issue to share the presentation. So, what is this counterfeiting? Combating counterfeiting. So, the International Framework Trademark Association gave a special report on this counterfeiting in 2004. If you go to that report, it follows, it gives some measures to protect the counterfeiting. That is, in the case of intelligence, and in the case of background preparation, in the case of differentiation. So, in these three fields, they give the some guidelines with regarding to the how to combat the counterfeiting. And in the case of IPR litigation, so initially the IPR litigation starts with, basically the IPR litigation can be divided into three main stages. First, at the time of making the IPR application, the office itself acted as some quasi judicial function. So, this decision of intellectual property offices, for example, commissioners and registrars, are obligated to interpret the law in order to carry out their functions properly. Many times, these decisions are treated as sacrosanct. Sacrosanct means it is pure. So sometimes these decisions should be followed. No one should violate these decisions. But if you are not interested on the decisions given by the intellectual property offices, then you can go to the Board of Appeal. It is a administrative procedure, appeal system in the administrative procedure. It working as a quasi-judicial function. So it includes issuing the pre-grant appeals and post-grant appeals. So for example, pre-grant appeals means, while if you are making some application, today you are submitting application and you are also due to some any reasons, they're registered after 1 week by saying that your payment was delayed due to some problems. Then you can go to the Board of Appeal by saying that there is a pre-grant appeal. So before that, your application procedure was done. So in that case, there is a pre-grant appeal. In the post-grant appeal, for example, a patent was given or an intellectual property right was registered, but for the maintenance of intellectual property rights, we are studied yesterday the time period or validity of intellectual properties. For example, in the case of patents, it is 20 years. So after in these 20 years, you have to maintain for that. For example, for every year, you have to pay some amount to that concerned patent office to maintain that patentability. But if you are not paying something, then this is comes under the post grant appeals. And final appeal, you can go to the court. The court is the final appeal. When disposing the appeal, the court normally may refuse the appeal, it may grant the appeal, it may refer the case back to the patent office for the reconsideration. Or if the decision appealed against was the decision to the reject the application. These are all the court can issue anything, whatever they thinks it is reasonable. So what is IPR litigation in India? In India, Trademark Act 1999 provides the establishment of Intellectual Property Appellate Board. So the central government shall, by notification in the official gazette, establish this appellate board, is known as Intellectual Property Appellate Board. This board is not bound by the procedure laid down in the Code of Civil Procedure, but it shall be guided by the principles of natural justice. So the principles of natural justice is a concept which was widely given in the administrative law. So in the case of principles of natural justice, there is two principles are very important. One is adi alteram partem, that is, hear the other side. Whenever a dispute was arised, the adjudicating authority has to listen the voice of both the parties and take the decision. So that is the basic requirement in the case of principles of natural justice. So these appellate boards, they generally they should not follow the civil procedural rules, but they follow the natural justice principles. The Intellectual Property Appellate Board has the same power like the civil court under the Code of Civil Procedure while trying the suits in respect of receiving any evidence, issuing some commissions for examination of witness, or requisition for any public record. Like that. What is the judicial system in India? So the judicial system in India consists of a Supreme Court, High Court, and the District Court. The Supreme Court is at the apex court, apex of judiciary system. It consists of Chief Justice and other judges appointed by the President of India. So it is the highest and final court of appeal in the India. So the High Court, the hierarchy second comes under High Court. The High Court is normally an appeal court and is highest court at the state level. It also consists of Chief Justice and other judges. It supervises the working of all the subordinate courts and make rules and regulations for the transaction of the business of the subordinate courts. The district courts, this functions under the superintendent and controls of the high courts. It is generally located in each district. Beside the district court, there are a court of sub-judges, municipal courts, and court of small causes. But as we previously said that with regarding to intellectual property right, which court has original jurisdiction to try the intellectual property right cases? That is district court. What comes under civil litigation? The basic objective of civil litigation are to provide compensation, or to provide any infringing copies, or to dispose implements used for infringing activities, or to grant injunctions in the case of civil litigation. So basically the remedy in the case of civil litigation are injunctions, damages, and account of profits. So preliminary remedies are the injunctions, interlocutory injunctions, like we are already discussed today itself only in the early time. That is set order and freezing order. Set order is also known as Hampton Pillar order. Freezing order is known as Mareva injunction. And the accounts of profit. The assessment of damages in industrial property cases invariably demands as a first step an election by the successful plaintiff as to whether he will take an inquiry as to the damage on the one hand or the account of profits on the other hand. So here the plaintiff has the limited opportunity, either he choose take an inquiry or whether he choose the account of profits. What about criminal procedure? So basically, India has effectively resorted to the criminal procedures of the protection of intellectual property rights. Based on the TRIPS agreement, Indian IPR laws also provide criminal procedures for deterrent of infringement. The TRIPS agreement provides infringement or monetary funds, or monetary funds, penalties, at the same time, seizure or forfeiture, and destruction of infringement goods. The Copyright Act 1957, it also provides some criminal provision. That is, the Copyright Act provides both infringement and fine to deter the violation of the copyright. If the infringer shall be punished with the imprisonment which shall not be less than 6 months, but which shall may extend to 3 years, and with a fine which shall not be less than 50,000 and which may extend to 2 lakhs. But if subsequent convictions, then the imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years, and the fine shall not be less than 1 lakh, but which may extend to 2 lakh rupees. In the Trademarks Act, the penal provision or criminal provision for the infringer talks that the infringement for a term which shall not be less than 6 months, but which may extend to 3 years, and with a fine which shall not be less than 50,000, but which may extend to 2 lakhs. And for subsequent conviction, the imprisonment which shall not be less than 1 year, but which may extend to 3 years, and the fine is not less than 1 lakh, but which may extend to 2 lakhs. And the Patent Act also provides the imprisonment for a term which may extend to 2 years, or with fine, or with both, to the acts of the infringement. The Design Act also consists of penal provision. That is, it grants a sum not exceeding 25,000 rupees recoverable as a contract debt against the infringer. So, what is the legal framework of intellectual property rights in India? So, these are the list of enactments which was enacted and which gives the protection of respective intellectual property rights. For example, trademarks governed under the Trademarks Act 1999, copyrights governed under the Copyright Act 1957, like that. So settlement of disputes through ADR methods. What comes under ADR methods? You all know that ADR mechanism used to resolve disputes without the need for litigation in court. It offers a quicker, less formal, and often less expensive way to resolve conflicts. So there are types of ADR methods. One is arbitration, mediation, negotiation, conciliation. What comes under arbitration? Is nothing but arbitration means a process where disputing parties agree to submit their dispute to a neutral third party who makes a binding decision. Okay, in this case, the arbitrator was appointed by the court. So this arbitration decision should be binding on the parties. Now, mediation. The mediation facilitates a negotiation process where a neutral third party helps the disputing parties to reach a voluntary agreement. That means here the mediator does not make a decision, but he imposes a solution to help to guide a mutually accepted resolution. So because of this, the mediation agreement is not so binding until unless if it is accepted by the parties. Negotiation. It is a direct discussion between the parties involved in the disputes aimed at reaching a mutually acceptable agreement. Sometimes it may not have a third party also. What about conciliation? It is a conciliation is other form of mediation where conciliator play more active role in proposing solution. So what are the advantages of ADR? So advantages of ADR is nothing but cost effective compared to litigation, civil or criminal litigation, court procedure. So costs are very less. Time saving, confidentiality also there. So because of the private agreements of this arbitration mediation, so it should not be in public, so it should make confidential. Flexibility, so usually you can choose the arbitrators or mediators based on your interest, and it also preserves the relationships because see what happened in the case of courts. Once a dispute went to the court, then the parties involved in the dispute, after deciding the judgment, uh, the parties were not in a good relationship. But in the case of ADR mechanism, in the case of negotiation, mediation, conciliation, so the mutual agreement will be written. So the mutual agreement means the relationship should be subsisted. So this is one advantage of the ADR. And some disadvantages of ADR also there, that is limited appeal. So, but if you see the arbitration procedure, arbitration agreement is the final. So there is no appeal. At the same time, these ADR methods are not suitable for all the disputes. At the same time, the last one disadvantage is nothing but power imbalance. If any party which is more power compared to other party, then obviously in the case of ADR mechanism, the judgment should be not, we can say should be biased, but we can conclude that it is not fair and reasonable. So introduction to mediation in intellectual property rights. I also told you that what comes under mediation. So benefits of mediation over litigation, same benefits of ADR, so cost effective, confidentiality, flexibility, and control are there. The mediation process and stages. What are the stages involved in the mediation? Pre-mediation, mediation session, agreement and documentation. So the pre-mediation stages involves the preparation of the mediation session, in the mediation session, it is nothing but to collecting the evidences, everything. Agreement and document. After once the final mutual approach is reached, then you have to um, write the agreement. Once you write the agreement, then you make them as a legally binding agreement, because the mediation itself is not legally binding. So you have to make the document as a legally binding agreement. Then it becomes enforceable. Next, the role of mediators. So the role of the mediators can be as a facilitation. So the mediators were not involved in the active process, but they are involved. The mutual make them mutually agreed and impartiality. So the mediators shouldn't act as partials. It, the mediators should problem solving and creative. Yes, absolutely. And they have to maintain confidentiality. Confidentiality and enforcement of mediation agreements. Whether the mediation agreements is confidential, yes, because the mediation done in private place. So without the consent of that parties, the third parties cannot access the mediation agreement. So it is confidential. Yeah, it is enforceability. Mediation agreements are legally binding once if you make them legally binding. Next, court involvement. Sometimes, yes, while mediation is an alternative to litigation, but to enforce mediation agreement, you can go to the courts. So record keeping, you have to maintain record documents. Advantage of mediation in IPR disputes. So yeah, that is already discussed. Speedy and efficiency, cost effectiveness, flexibility and control, preservation of relationship, creative solutions. What are the challenges and the limitation of mediation? This is also imbalance, lack of legal guidance, limited binding authority, lack of procedure, due process of law. So this comes under the challenges in the case of mediation. Termination of mediation. When should the mediation should be terminated? The mediation shall be terminated by signing of a settlement agreement by the parties, or if the mediator decides that the mediation is unlikely to lead to a resolution of the dispute, or by a written declaration of a party at any time after attending the first meeting of the parties with the mediator and before the signing of any settlement agreements. So, in these three conditions, that mediation of termination happens. The administration fee and cost. The request for a mediation shall be subject to the payment of required administration fee to the center. The administration fee shall not be refunded. If the party fails to pay the administration fee to the center within 15 days after the second reminder in writing, it shall be deemed to have withdrawn its request for mediation. Next, the settlement of dispute through arbitration. In the case of arbitration, arbitrators will be appointed by the court. What are the definition and key characters of arbitration? So, in the case of arbitration, the neutral third party involved, the decision is binding. What are the key characteristics of arbitration? Is the voluntariness. The disputed parties can go voluntarily to the solve the problem through the arbitration. And the neutrality. the arbitrator must maintain the neutrality between the disputed parties, and the binding decision, the arbitrator decision, is known as the arbitration award, is final and legally binding on the parties unless grounds for challenging it exists. So advantages of arbitration over litigation. Yeah, same as mediation and ADR methods, the confidentiality, flexibility, the expertise. Whom should be the arbitrator? The court should appoint a person who was expertise in that particular field in the case of arbitration. So the expert arbitration which leads to the experienced persons. So what is the arbitration procedure? As you see in the mediation procedure, same, the demand of arbitration happens. Response and pre-hearing procedures happen. Arbitration hearing. After that, arbitration decision. Selecting arbitrators and establishing the tribunal. So what are the qualifications? What are the impartiality, availability of how you can select the arbitrator? So based on the experience, so arbitrator can appoint. Preparing for arbitration hearing. So in the case of arbitration hearing, what should be they got evidence gathering, legal research, witness preparation. These are all go in the normal case procedure only. They're all gathering. Presence of evidence and arguments. How you can present the evidence and arguments. After once you present the evidence during the arguments, there is a direct examination and there is a cross examination and there is a closing arguments. In the case of direct examination, the advocate asked the respected party to give his witness. But in the case of cross examination, the advocates will ask other party to give their testimony, and by closing arguments, the advocates summarize their arguments, highlighting the evidence presented before the court. So this is the process of presenting the evidence and arguments. Issuing of arbitration award based on this evidence and arguments, the arbitrator or arbitrators make a written decision known as arbitration award, which is legally binding by the parties. If any party in future violates that award, then it can be the other party can go to the court. So enforcement of arbitration award. The arbitration award can be enforced in domestic enforcement also, at the same time international enforcement also. What are the fees and costs of this arbitration award? Same as in the case of mediation, the party who shall pay a non-refundable registration fee for the center to the center. If a claimant or a respondent do not pay the fee within 15 days after a second reminder in writing, the arbitration will be deemed to have been withdrawn. The claimant shall pay an administrative fee to the center within the 30 days after receiving notification from the center. If a party fails to pay administration fee within 15 days after the second reminder, it will be deemed to be withdrawn its claim. So the last chapter of today's lecture is the introduction to the Indian Arbitration and Conciliation Act 1996. So basically this 1996 Arbitration Conciliation Act is a landmark legislation that governs resolution of disputes through arbitration and conciliation in India. This was enacted due to the lot of work pressure, lot of pending litigation before the court. So they adopted alternative dispute mechanisms. So this 1996 Act replaced the earlier Arbitration Act of 1940, which was considered outdated. So this was enacted. This act has significantly contributed to the growth of arbitration as a preferred method of dispute resolution in India. So what are the key features of the act? So party autonomy, neutrality and impartiality, procedural flexibility, enforcement of awards. So these are the key features, as we see in the key features of arbitration and mediation in the previous slides. These same are the key features of this act also: autonomy, neutrality, impartiality, flexibility, award enforcement. Next, what is the scope and applicability of the act? The scope and applicability of, in the case of domestic arbitration, the act applies to the domestic arbitration where all parties to the dispute are subjected to the matter to the disputes are located in India. But in the case of international arbitration, the act also governs international arbitration, which at least one party to the dispute or a subject matter of the dispute is located outside India. It is also called as cross-border disputes. And in the conciliation, the act includes provisions for conciliation, which is also a form of ADR. This offers an alternative to arbitration where parties prefer a less adversarial approach to dispute resolution, that is conciliation. Arbitration agreement and its requirements. What requirements must be there to write an arbitration agreement? The writing requirement. The Act mandates that arbitration agreement must be in writing with clear and unambiguous and legal enforceability. Subject matter. The arbitration agreement must define the subject matter of the dispute and the designated officer, designation of the arbitrators. The designation of officers must be essential to ensure fair and impartial procedures. So they should appoint competent persons, expertised persons as arbitrators. Signatures of the parties. The arbitration agreement must be signed by the parties or their authorized representatives. This signifies that they consent to be bound by the terms of the agreement and to submit to the arbitral process. Appointment of arbitrators. The arbitrators can be appointed by the parties. The arbitrators can be appointed by the third party known as court. Okay, so the act also consists the provision talks about the challenges to appointment of arbitrators. So if a impartial person or if a person who is not neutral, if anyone appoints, then you can challenge their appointment also. So what is the procedure regarding the arbitration? So first, commencement of the proceedings. Second stage is exchange of pleadings. Third stage is discovery and evidence. Fourth stage is hearing and submissions, and fifth stage award. Same as the procedure, as like in the court itself only. First, the commencement of the case. Second, the pleadings of exchange of pleadings. Fourth, if any evidence is there, you have to produce. And fourth, hearings, cross hearings, submissions, final submissions. And finally, the competent person who is in the adjudication place, he can award the arbitration, or in the case of court. The powers of arbitration tribunal. It conduct proceedings, issue take evidence, rule on admissibility of evidence, make interim applications, So what comes under interim measures and court assistance? Already talks about interim injunctions. Interim measures is nothing but injunctions. Recognition and enforcement of arbitral award. So the arbitral award are generally considered final and binding on the parties. So the Act provides for limited grounds for challenging an award, such as on ground of fraud, corruption, or violation of the public policy. So this arbitration award can this Arbitration and Conciliation Act provides mechanism for the enforcement of arbitral awards both within and outside the India. So parties can apply to the court for the enforcement of the award, and the court will generally grant the enforcement if certain requirements are met. So finally, what recent amendments and developments with regarding to this act happens? So with regarding to recent amendments, notable amendment is in 2015, which introduced significant changes to the law, including provisions for expedited arbitration, increased party autonomy, and strengthened enforcement mechanisms. The Act continues to be a subject of ongoing debate and discussions, with several proposals for future amendments to enhance its effectiveness and efficiency. Even though still the arbitration and conciliation is there, but still there is a lack of legal awareness. So no one, so many of people are not taking this opportunity to deal with the cases with the Arbitration Conciliation Act, so ADR mechanism. So these are the challenges with regarding to Indian Arbitration and Conciliation Act. So with this, today's class is concluding. We are discussing both IPR enforcement and intellectual property rights litigation and settlement of disputes. So yesterday and today we are completed the paper 1 code MIR021. So tomorrow and the remaining 2 days we are discuss with second paper, which talks about international framework patent protection. Okay.
Sir, all the sessions have been completed, na? All the topics. Hello?
Yes, sir. Yes, sir. Yes, sir. In the first paper,
all
the topics are completed.
All the syllabus has been covered, na?
Yes, yes, sir.
Hello?
The first paper, all the syllabus is completed. Yes, sir. Yes,
Okay.
sir. With regarding to the first
Any
paper,
any need for one more session? Not required.
no, sir.
Yeah.
With regarding to first paper, all was covered.
Okay. Anjali, you want to ask something?
Sir, it's related to MIR21. That the course is completed in
Yes.
that regard. Okay, sir.
Yes.
22 tomorrow onwards. Okay, then good. Thank you, Mr. Ramanamurthy and the students. Now it is over, na, sir, class, sir? Okay, we are uploading every day lectures in our YouTube channel. Any your friends not attended also, they can watch the same. Okay, thank you.